Well, I am Debajit Kumar Sarmah, Assistant Professor in the Department of Law, Tezpur University, Assam, and I will be discussing with you this topic of probation and alternative to imprisonment. As we all know, Section 53 of the Indian Penal Code recognizes 5 different types of punishment, which are death, imprisonment for life, imprisonment rigorous, that is with labor, or simple imprisonment, forfeiture of property, and finally the fine. But the Indian Penal Code does not mention punishments such as community sentencing like probation or parole, and also that of community service, which the legislations like the Juvenile Justice Care and Protection of Children Act 2015 recognizes. In case of imprisonment or as in under trial, when a person is sent to the prison or jail, he or she gets stigmatized. There is contaminating influence of hardened criminals in jails, and the basic facilities of prison life may also be lacking because of overcrowding of jails. Most importantly, he or she suffers from disqualification attaching to conviction if she or he happens to be a convict, and regarding this particular aspect we are going to elaborate in detail later on. Now, when we talk about probation, now probation in this context means and implies that there is a suspension of sentence by the court. That means sentence in the literal sense of the term is not imposed. Offender remains in the community until the length of the sentence has expired, unless of course in the meantime he or she has engaged in a conduct that would warrant carrying out the sentence. Hence, the twin purposes served by this are another chance given to the offender, and number 2 is a threat of punishment if he or she fails to improve his behavior. Now, if we look at the history of probation, we find that this whole concept of or the word probation is derived from the Latin word probatum, which means the act of proving. In probation thus, when an offence is proved by the court of competent jurisdiction, the court, instead of convicting the offender by sending to prison, gives an opportunity to lead his or her life by staying in the community. As you all know, imprisonment is an accepted form of punishment in the world at large. It serves 3 important purposes, that is retribution, prevention and deterrence. However, what imprisonment fails to achieve because of several reasons are reformation and reintegration of persons. Although prisons are classified as correctional institutions and prison administration as correctional administration, what constrain these institutions are overcrowding, insufficient prison staff, inadequate allocation of budget in many states, and most important is the lack of proper understanding of punishment and correction among different stakeholders. Probation needs to be seen from that very perspective as an alternative to imprisonment. The founder of probation was John Augustus, a bootmaker of Boston and a member of a society working against alcoholism in 1841. In 1878, law of probation was implemented for the first time in America. The Indian Jails Committee report of 1919-1920, for the first time, the principle of reformation was manifested. After independence, in 1951, the visit of Dr. W.C. Reckless, an UNO subject expert, and in 1952, All India Conference of Inspectors General of Prisons in Mumbai were significant developments in the history of probation as far as India is concerned. When you look at the whole idea of probation, that also needs to be seen from the broader context of different criminological underpinnings to it. Now, when you talk about criminology, we find that human thinking and reasoning about crime, punishment and justice progressively evolved from the neoclassical times to classical school and to the positive school, and it's still evolving in contemporary world. Now, the classical school laid the basic principle that the punishment should fit the crime, whereas the positive school of criminology, which is led by Lombroso, Enrico Ferri and Garofalo, they change the whole trust of the understanding of crime, justice, punishment and justice to the fact that the punishment should fit the criminal. Now, the positive school of criminology rejected the free will theory propounded by the advocates of the classical school like Beccaria and Bentham, and instead look at the factors within the criminal, that is physical, biological and the mental traits. When we look at the Indian Penal Code, we find that Indian Penal Code was in fact enacted when the classicalism was prevalent and positivism was emerging. But the concepts such as probation got wider recognition with the influence of positive school of criminology. Madras was the first Indian state to have a law on probation in 1936, and subsequently the Probation of Offenders Act was enacted in 1958 as a central legislation. Now, coming to the legal aspects of probation, we find that Section 562 of the Criminal Procedure Code was the earliest provision. In fact, I would like to mention here that the first statutory expression to the penal system reflecting probation philosophy was Section 562 of CRPC of 1898. This particular provision dealt with probation. Now, it stated that released on probation the first time offenders in the discretion of the court for minor offences up to 2 years of imprisonment. Now, Criminal Procedure Code of 1923 was liberalized to the tune of our present CRPC of 1973. Now, in the present CRPC, we find that there is Section 360 which states release on probation of good conduct or after admonition upon judicial discretion. I would like to draw the attention here to the words upon judicial discretion. Now, Section 360 of the CRPC stipulates that number 1, offenders above the age of 21 years, offences punishable with fine only or imprisonment for 7 years or less, both under the penal code as well as under special or the local laws. This particular provision pertains to only offenders who is below the age of 21 years. This particular provision also stipulates that young male offenders under the age of 21 years and all female offenders except those punishable with death or life imprisonment. That means both offenders who are above the age of 21 years and below the age of 21 years can be released on probation by an interpretation of 360 of the Criminal Procedure Code of 1973. But I also would like to draw your kind attention to another feature of Section 360 of CRPC, which says that no previous conviction is proved. Now, when we read the Probation of Offenders Act that we are going to do after some time, we find that Section 4 of the Probation of Offenders Act allowed probation to repeat and petty offenders. This is an important distinction between Section 360 of CRPC 1973 and that of the Probation of Offenders Act 1958. Release after admonition. Now, what is admonition? First of all, we need to understand. Admonition is basically when an offender is released after giving a warning. Now, in what all cases admonition can be given or person may be released after admonition under CRPC? Now, cases of theft, theft in a building, dishonest misappropriation, cheating or any offence under IPC punishable with not more than 2 years of imprisonment or any offence punishable with fine only. Also, what is being laid down under Criminal Procedure Code is that a person may be released after admonition only if there is no previous conviction. Here we also see a very important distinction of the Criminal Procedure Code with that of the Probation of Offenders Act in terms of the fact that admonition under the Probation of Offenders Act can be given under for an offence under IPC or under any other law for that matter. But whereas a person may be released after admonition under Criminal Procedure Code only for those offences which are punishable under Indian Penal Code. Now, what we have seen is that the Criminal Procedure Code of 1973 and also we are going to look at the Probation of Offenders Act of 1958. The issue is The Probation of Offenders Act 1958 or other children related legislation, do they override section 360 of the Criminal Procedure Code wherever these legislations are enforced? The Honorable Supreme Court recently in a criminal appeal Lakhanlal Singh versus State of Madhya Pradesh, however, held as under. We find that attention of the court was not drawn to subsection 10 of section 360, which provides that section 360 will not affect the provisions of 1958 Act or other similar laws for the time being in force for the treatment, training or rehabilitation of youthful offenders. Still further, section 4 of the 1958 Act has a non-abstentive clause giving overriding effect over any other provisions of law. The conjoined reading of the provisions of both the statutes, we find that the provisions of section 360 of the code are in addition to the provisions of the 1958 Act or the Children Act of 1960 or any other law for the time being in force for the treatment, training or rehabilitation of youthful offenders. Now, in this particular case, the High Court held that section 360 of the Code of Criminal Procedure Code will not be applicable as the matter falls within section 3 and 4 of the Probation of Offenders Act of 1958. This distinction that I am trying to draw your kind attention to is very important for a student of law, because under the 1958 Act, the court is required to seek report from the probation officers before allowing an offender the benefit of probation apart from satisfying other conditions, whereas there is no such limitation while exercising the powers under section 360 of the Criminal Procedure Code of 1973. Further, we find that section 361 of the Criminal Procedure Code states special reasons to be given for not granting benefit under section 360 and under the Probation of Offenders Act of 1958. Now, let us look at the scheme of our central legislation, that is the Probation of Offenders Act of 1958. Now, this Probation of Offenders Act of 1958 serves two important purposes, that is admonition and probation. The scope of this Act is as such: number 1, release of offenders on probation or after due admonition and for matters connected therewith. There are total 19 sections in the Probation of Offenders Act of 1958. This particular law or the legislation is applicable to the whole of India except J&K, and states have been empowered to bring in force the law and frame rules pertaining to this particular Act. Assam, for instance, has the Probation of Offenders Rules 1962. Now, section 3 of the Probation of Offenders Act talks about admonition. As I have already stated, admonition is nothing but releasing an offender after giving a warning. In what all cases a person may be released after due admonition are those: number 1, section 379 of the Indian Penal Code, 380, 381, 404, 420, or punishable with imprisonment for not more than 2 years or with fine or with both under IPC or any other law. What is also important for the purpose of admonition under the Probation of Offenders Act 1958 is that the person should not be a habitual offender. That means there should be no previous conviction proved. Now, it is important for us to understand here is that somebody is released under section 4, that is the subsequent section that we are going to talk about, or an order made under this section or under section 4 of the Probation of Offenders Act shall be considered as previous conviction. After section 3, the most important section is section 4. Under section 4 of the Probation of Offenders Act, any person may be released on probation if the offence is not punishable with death or imprisonment for life upon the objective satisfaction of the court and on his entering into a bond with or without sureties. The maximum duration is for 3 years, provided offender or his surety has a fixed place of abode or regular occupation. The court shall take into consideration the report, if any, of the probation officer supervision order to remain under a probation officer, which is not a mandatory condition under this section, is for not less than 1 year. Court may impose such conditions as it deems necessary for the due supervision of the offender. It is important for us to understand here is that a person may be released on probation in the discretion of the court, having regard to the circumstances of the case, including the nature of the offence and the character of the offender. As per section 4 of the Probation Offenders Act of 1958 concerned, there is a very important judgment of the Supreme Court, that is MHRD versus State of Delhi, AIR 2005 SC 2685. In this particular case, what was held was that the court is bound to call for a report as per section 4 of the Act, but the High Court has failed to do so, although the court is not bound by the report of the probation officer, but it must call for such a report before the case comes to a conclusion. That means the report of the probation officer is very important. If available, the court must call for a report of the probation officer. It is a different matter altogether whether the court concurs with the findings or with the report of the probation officer, but they have to take that particular report into consideration. The word shall in subsection 2 of section 4 is mandatory, and the consideration of the report of the probation officer is a condition precedent to the release of the accused. Why I am mentioning about this particular judgment of the Supreme Court? Because the earlier judgment made it not mandatory but absolutely essential, except when such a report is not forthcoming or sufficient material on record justifying the use of discretion conferred under this section. Now, section 5 of this particular act talks about victim compensation and the cost. It lays down that the whole aspect of victim compensation and cost is purely in the discretion of the court when an offender is released under section 3 or under section 4. However, there is no compensation if the offender is below the age of 21 years. After section 3, that is admonition, section 4, that is probation, another important section that we find mentioned in the Probation Offenders Act is section 6, which is restrictions on imprisonment of offenders under 21 years of age. Now, this particular section lays down that this restriction of imprisonment and reasons shall be recorded by court for not dealing with the offender under section 3 or under section 4. The offence needs to be punishable with imprisonment, but not imprisonment for life. That means if the offender is below the age of 21 years, the court has to record reasons for not releasing him under probation or not giving him the benefit of probation. However, what is important for us to remember here is that the offence for which the person is released should not be punishable with life. The report of the probation officer here is mandatory. Now, when you say 21 years, when is 21 years? Whether at the time of the commission of the offence or at the time of being arrested by the police or at the time of being convicted by the court of competent jurisdiction. The important case, that is Ramji Ratan Lal versus State of Punjab in 1964, held that 21 years is to be calculated at the time of conviction only. After section 6, the very important section of the Probation Offenders Act is section 12, that is removal of disqualification attaching to conviction. This particular provision states that an offender shall not suffer any disqualification attaching to conviction of an offence under such law if the offender is dealt under section 3 or under section 4. In fact, section 12 serves the fundamental cause of reformation in as much as it helps the offender not to be branded as a criminal and instead to get rehabilitated in the society. Unfortunately, this provision has received very restrictive interpretation by the courts in India, including the Honorable Supreme Court. Let us see how it is. In a case of Shankar Das versus Union of India, AIR 1985 SC 772 held that the order of dismissal from service consequent upon a conviction is not a disqualification within the meaning of section 12. There are statutes which provide that persons who are convicted for certain offences shall not incur certain disqualifications. For example, chapter 3 of the Representation of People Act 1951 entitled Disqualification for Membership of Parliament and State Legislature, and chapter 4 entitled Disqualification for Voting contain provision which disqualify person convicted of certain charges from being member of legislature or from voting at election to legislature. That is the sense in which the word disqualification is used in section 12 of the Probation of Offenders Act. Another important case of Delhi High Court, that is Debajit Kumar versus Commissioner of Police and others 2010, also affirmed the above position and held that a person was not fit to be appointed as a police constable in Delhi Police as he was guilty of having committed an offence under section 308 of IPC, though was released under section 4 of the Act on probation with a bond of 2 years. Now, this trend of giving very restrictive interpretation to section 12 of the Probation of Offenders Act started from the case of Divisional Officer versus T.R. Salapan 1976, wherein the Supreme Court ruled that the order of release on probation is merely in substitution of the sentence to be imposed by the court, and that the factum of guilt on the criminal charge is not swept away merely by passing the order releasing the offender on probation. Post these particular judgments of the Supreme Court is more or less on the similar lines. What is worrying is that such restrictive interpretation of a beneficial legislation would defeat the very purpose with which such a legislation was enacted. In fact, section 12 is the heart of the Probation of Offenders Act, as it is very clear from the following sentence or the following part of the Probation of Offenders Act, and I quote here: "Notwithstanding anything contained in any other law, a person found guilty of an offence and dealt with under provisions of section 3 and 4 shall not suffer disqualification, if any, attaching to a conviction of an offence under such law." Now, the probation officers play a very important role for the success of this legislation or for the implementation of this legislation. Section 13, 14 and 16 of the Probation of Offenders Act are dealing with probation officers. Now, these probation officers are appointed by the state government or recognized as such by the state government, persons provided for this purpose by society recognized in this behalf by state government, or any other person in exceptional cases if found fit to be a probation officer in the opinion of the court. That means a person working with a non-governmental organization, or a person working in the criminal justice administration may also be appointed as a probation officer in the discretion of the court, and they are under the control of the district magistrate. The probation officers are to assist the court and the offender at every stage, including pre-sentence report, supervision, payment of compensation, etc. Section 21 of the IPC recognizes the fact that probation officers are public servants within the meaning of that particular provision. Now, report of the probation officers find mentions in the Juvenile Justice Care and Protection Act of 2015 as well, as also in the Brostell Schools Act of different state. So, what I mean to state here is that the probation officers, whether government employees or being appointed by the court from amongst the people working with the non-governmental organizations, play a very important role, and their report is crucial for the court to come to a definite conclusion whether somebody may be given the benefit of probation or not. Now, after looking at this particular legislation, what comes to my mind is, what is the benefit of this particular medium of sentence or the mode of punishment? Is it a sentence? Yes, it is a form of community sentence. But what is important for us to understand that deinstitutionalization rather than imprisonment will always have a positive impact and a non-criminalizing effect on the offender. Identity loss and isolation behind the bars leave a very negative impact in the mind of the prisoner. If you want to avoid that kind of a impact on the offender, non-institutionalized or, as I have stated, deinstitutionalized modes of punishment is something that we need to think about. Probation is a correctional law and its effective implementation, especially for the neglected and disadvantaged groups in custody, is very, very important. Also, this particular concept, this particular legislation needs to be seen in the context of increasing crime rate and overcrowding of prisons. The recent prison statistics being released from National Crime Records Bureau of India records that the under trial population in Indian jail is 67.68%. The probation officers also should be involved in other correctional techniques such as parole and furlough. Probation officers can also help out inmates who are arrested under preventive action for minor offences. But the structural reforms of the probation system is required in India, especially in terms of workload and remuneration to the probation officers in many states in India. District Legal Services Authority can play a very important role even when Sessions Court does not call for the report of the probation officer. In DLSA, any application to help the court must be considered. Another important thing that which was guidelines were framed in R.D. Upadhyay versus State of Andhra Pradesh in 1994 regarding care to be taken with regard to the children of imprisoned mothers. The probation officer's intervention is crucial for them also. The sensitization of judiciary on probation is another concern today. The prison is a state subject. There is no ministry to look into it, except that the Bureau of Police Research and Development has a correctional administration wing and the Ministry of Home Affairs has a correctional administration division. Therefore, correcting the correctional system should be a priority in India today. We should really have a very great impact on ambitious philosophies and ambitious techniques such as probation, parole and so on and so forth. Thank you.